Hi friends, welcome to my channel again. In this video, I'm going to give you a dictation on euthanasia and speed is 100 words per minute. Let's start with the dictation. Last 5 seconds. 4, 3, 2, 1, start. The word euthanasia originated in Greece means a good death. Euthanasia encompasses various dimensions from active introducing something to cause death to passive withholding treatment or supportive measures, voluntary consent to involuntary consent from guardian, and physician assisted, where physicians prescribe the medicine and patient or the third party administers the medication to cause death. Request for premature ending of life has contributed to the debate about the role of such practices in contemporary healthcare. This debate cuts across complex and dynamic aspects such as legal, ethical, human rights, health, religious, economic, spiritual, social aspects and cultural aspects of the civilized society. Here we argue this complex issue from both the supporters and opponents' perspectives and also attempts to present the plight of the sufferers and their caregivers. The objective is to discuss the subject of euthanasia from the medical and human rights perspective given the background of the recent Supreme Court judgment in this context. In India, abetment of suicide and attempt to suicide are both criminal offences. In 1994, constitutional validity of Indian Penal Code section IPC 309 was challenged in the Supreme Court. The Supreme Court declared that IPC Section 309 is unconstitutional under Article 21 right to life of the Constitution in a landmark judgment. In 1996, an interesting case of abetment of commission of suicide IPC Section 306 came to Supreme Court. The accused were convicted in the trial court and later the conviction was upheld by the High Court. They appealed to the Supreme Court and contended that right to die be included in Article 21 of the Constitution and any person abetting the commission of suicide by anyone is merely assisting in the enforcement of the fundamental right under Article 21. Hence, their punishment is violation of Article 21. This made the Supreme Court to rethink and to reconsider the decision of right to die. Immediately, the matter was referred to a constitution bench of the Indian Supreme Court. The court held that the right to life under Article 21 of the Constitution does not include the right to die. Regarding suicide, the Supreme Court reconsidered its decision on suicide. Abatement of suicide IPC Section 306 and attempt to suicide IPC Section 309. It has also clearly stated that a person attempts suicide in a depression and hence he needs help rather than punishment. Therefore, the Supreme Court has recommended to Parliament to consider the feasibility of deleting Section 309 from Indian Penal Code. Euthanasia opposers argue that if we embrace the right to death with dignity, people with incurable and debilitating illness will be disposed from our civilized society. The practice of palliative care counters this view, as palliative care would provide relief from distressing symptoms and pain and support to the patient as well as the caregiver. Palliative care is an active, compassionate, and creative care for the dying. Right to life is a natural right embodied in Article 21, but suicide is an unnatural termination of or extinction of life and therefore incompatible and inconsistent with the concept of right to life. It is the duty of the state to protect life and the physician's duty to provide care and not to harm patients. If euthanasia is legalized, then there is a grave apprehension that the state may refuse to invest in health working towards right to life. Legalized euthanasia has led to a severe decline in the quality of care for terminally ill patients in Holland. Hence, in a welfare state, there should not be any role of euthanasia in any form. Attempts to suicide or completed suicide are commonly seen in patients suffering from depression, schizophrenia, and substance users. It is also documented in patients suffering from obsessive compulsive disorder. Hence, it is essential to assess the mental status of the individual seeking for euthanasia. In classical teaching, attempt to suicide is a psychiatric emergency and it is considered as a separate, disparate call for help or assistance. Several guidelines have been formulated for management of suicidal patients in psychiatry. Hence, attempted suicide is considered as a sign of mental illness. In the era of declining morality and justice, there is a possibility of misusing euthanasia by family members or relatives for inheriting the property of the patient. The Supreme Court has also raised this issue in recent judgments. Mercy killing should not be led to killing mercy in the hands of the noble medical professionals. Hence, to keep control over the medical professionals, the Indian Medical Council Professional Conduct Etiquette and Ethics Regulations 2002 discusses euthanasia briefly in Chapter 6, Section 6.7, and it is in accordance with the provisions of the Transplantation of Human Organ Act 1994. There is an urgent need to protect patients and also medical practitioners caring the terminally ill patients from unnecessary lawsuit. Law Commission had submitted a report number 196 to the government on this issue. Stop. So guys, this was a dictation at the speed of 100 words per minute on euthanasia. If you like the dictation, you can subscribe my channel and like this video. And if you have any suggestions for me, any advice, you can comment on the comment box. Thank you guys.